Judge Boasberg came in on March 15th by issuing a TRO from removing any of the individual.
Like, this is why he's a lib, you know what I mean? Because, like, Boasberg is not exactly a woke libtard himself, you know what I mean? He's I kind of want to watch this legal eagle video. What happens when he ignores court orders? This is precisely the case. This is precisely the case that may happen.
Lawyers live by judge tells us to do something, we do it. That doesn't mean we always like it, and it doesn't mean we won't try to find other arguments to achieve the same ends. We're kind of like teenagers in that way. But at the end of the day, we roll our eyes privately and comply with what the judge tells us to do. And when we disagree with the ruling, the right thing to do is obey the judge's order and appeal until the last court tells us no. And because thousands of lawyers follow this basic rule every day, the rule of law survives. But right now, the rule of law is in peril because President Trump has decided he doesn't have to follow the court's orders he doesn't like. Sort of. It's complicated. He's refusing to comply, but saying that they are complying.
On Air Force One last night, he was asked, did his administration violate the judge's order?
I don't know. You have to speak to the lawyers about that.
But it seems we may have the clearest case of the executive defying a direct court order in American history. And it looks like things are only going to get worse. Now, as we've already explained, the ACLU got wind of a Trump plot to massively expand and fast-track deportations without a fair legal process. The Alien Enemies Act of 1789 is a controversial law that purports to allow the government to deport foreign nationals during wartime. But Trump has invoked this act to justify deportations during peacetime. And Trump asserts that the act allows him to deport certain immigrants on the grounds that they are members of a Venezuelan gang. Of course, so far all this has happened without any due process whatsoever, meaning that we don't know that any of these people are actually members of a Venezuelan gang. And as long as the president says that they are a member, they can be deported, actually renditioned to a foreign country that they're not even from. And that means possible that even American citizens could get swept up in this whole process. Which is why we spent an entire video going over how terrible all of this is. But the ACLU filed an emergency lawsuit asking a federal judge to stop the renditions. On March 15th, U.S. District Judge James Boasberg issued a 14-day temporary restraining order halting the deportation of over 200 Venezuelan immigrants. The judge even told the government that if the planes were in the air, they needed to turn around. And despite that order, the administration proceeded with the deportations. At a hearing, the DOJ lawyers asserted that Trump had the power to deport immigrants and that he could keep his reasons secret from the court. And the judiciary exists to interpret and enforce the law, ensuring that the executive and legislative branches operate within constitutional limits. But the Constitution contains a potentially fatal flaw. It doesn't give the courts a way to enforce their orders. That's why the system depends on all of us recognizing the court's authority. And when the executive branch defies a court order, it effectively declares that the judicial authority is meaningless.
Yeah. It's just like when you turn around and say, like, yeah, I'm not following the court orders, then like the entire system falls apart. Because it's entirely predicated on the persuasive power that the judiciary has. It's the only thing that they have, which is why I was very critical of the Supreme Court's previous decision exercising its persuasive power, because they were worried that Trump could simply ignore it, signaling that the judiciary has no power whatsoever. Does that make sense?
Potentially eroding the rule of law. And it seems the Trump administration's actions have finally triggered the constitutional crisis we've been dreading all along. So today we're going to talk about what happens if the president ignores a direct court order. Schoolhouse Rock laid this all out for us.
No one part can be more powerful than any other is. Each controls the other, you see, and that's what we call checks and balances.
And that's a pretty nifty system when it works. But Trump is theoretically not the first president to face off with courts. Presidents like Andrew Jackson and Abraham Lincoln are often cited as examples of leaders who defied judiciary. However, the myths surrounding their actions don't quite match with the reality. What Trump is doing right now is putting us in completely uncharted waters. For example, in Worcester versus Georgia, the Supreme Court ruled that the state of Georgia could not impose its laws on Cherokee land. And that case contributed to the horrible episode in American history known as the Trail of Tears, where thousands of Native Americans were forcibly relocated. President Jackson criticized the court's ruling, and he allegedly said that Chief Justice, quote, John Marshall, has made his decision, now let him enforce it. But this quote is almost certainly apocryphal. Most articles about the presidency and the rule of law conclude that Jackson himself defied a court order, probably because of this probably incorrect quote. Jackson supported Georgia's defiance of the Supreme Court, and he did not send the marshals to enforce the Supreme Court's order. But it's a myth that he defied the court himself. Similarly, Lincoln is often thought to have defied the courts when he suspended habeas corpus during the Civil War. In the case of ex parte Merriman, Supreme Court Justice Roger Taney considered whether to grant a habeas petition by John Merriman. Taney was sitting as a circuit court judge at the time, so this wasn't a Supreme Court case. But the military accused Merriman of operating a secessionist terror cell. When he was arrested, he filed a petition in charge of Fort McHenry to appear at the hearing and to bring Merriman to the hearing itself. The government suspected Merriman of blowing up train, which would have cut DC off from the rest of the Union and could have altered the outcome of the Civil War.
Like, I'm thinking of Brown v. Board of Education. Or even, even in that situation, it's like, it's states themselves refusing to abide by the precedent set by the Supreme Court. This is a direct action that the Supreme Court is making a demand over. And the only person that would enforce this action is the federal government. It completely undermines the checks and balances if the federal government refuses to follow. It's a fairly direct destruction of the any kind of power that the judiciary has.
When a U.S. Marshal tried to enforce the order to bring Merriman to court for a hearing, the military refused him entry. Judge Taney ruled that the government should have brought Merriman to court, but he never directed President Lincoln or the general who had custody of Merriman to release him from confinement. Instead, he wrote an opinion that Merriman should be released. He asked the president to consider it, and then he served the opinion on President Lincoln. The entire case was over in 48 hours, and historians don't know if Lincoln was aware of the proceedings while they were happening. Merriman was eventually released on bail and wound up dragging out his treason trial until after the war ended. But the point is that Presidents Jackson and Lincoln did not directly ignore court orders in the way that the Trump administration seems to have been doing in these deportation cases. Now,
yeah, this is why I said it's like a little bit different, where it's the federal government not enforcing states' capacity to do harm versus the federal government directly refusing to answer to the judiciary. I guess it's in practice, it's the same outcome, kind of, but like it is new.
Now, before we get into the court's options, it should be noted that it's not always easy to determine if the government has violated a court order. Sometimes the government violates the spirit of an order without violating the letter of the law itself. And there are two recent examples of this. On March 6, President Trump issued an executive order suspending the security clearances for the law firm Perkins Coie, limiting the attorney's access to federal buildings. U.S. District Judge Beryl Howell granted a temporary restraining order against the enforcement of this order. But Trump then issued an executive order targeting another prominent law firm, Paul Weiss, using the exact same language enjoined by Howell. Now, we can argue that the Paul Weiss order will be enjoined for the same reason that the government should not have tried it again, and that's true, but Judge Howell's order doesn't apply to other law firms. As a side note, this is one of the reasons you should not be able to pass a bill of attainder in Congress or create effectively a bill of attainder by executive order either, but that's a topic for another video. But in any event, the two executive orders are different. One targeted one law firm and the other targeted a different law firm. So the first TRO doesn't apply to the second executive order. And Trump seems to be playing the same game with transgender people in prison. In January 2025, President Trump issued Executive Order 14168, mandating, among other things, that transgender women incarcerated in federal prisons be transferred to men's facilities and denied access to gender-affirming medical care. On February 25th, federal judge Royce Lambeth granted a preliminary injunction blocking the transfer of these transgender women to men's prisons and the termination of their hormone therapy. The Bureau of Prisons subsequently proceeded with transferring other transgender women to men's facilities, but kept the three named in the TRO where they were. While headlines said that the Trump administration ignored a court order, this probably isn't true. The administration complied with the letter of the order by not transferring the three named women to a men's prison, but now they face additional lawsuits on the
It's so fucking evil and gross.
same
dude.
grounds
Holy
related
shit.
to all the other people that they transferred. Now, while the courts have the right to say what the law means, and that goes back all the way to Marbury versus Madison, the Constitution doesn't give courts a clear way to enforce orders against a rogue president who refuses to follow the spirit of the orders or just outright ignore them. Now, if you are illegally renditioned to a foreign country, you're probably going to want a good lawyer. But if you want a great lawyer,
That's
let my firm, the
crazy.
Eagle Team, help. If you've got in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers'
That's a
comp or social security
crazy
issue,
ad,
we can
dude.
represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team, so click below. So when the government arguably disregards a court order, judges usually start by clarifying their orders and giving the government a chance to comply. This is happening right now in dozens of cases involving Trump's illegal executive orders. If the government doesn't comply, then judges may find them in contempt. And one thing you'll notice about everything that we're talking about here today is that this is a slow process. Courts have to lay a factual and legal foundation, and they have to slowly ratchet up the pressure over time. If they don't lay the correct factual or legal foundation, or they move too fast, then all of their decisions might get overturned on appeal. But generally speaking, contempt of court is defined as any act which is calculated to embarrass, hinder, or obstruct a court in the administration.
Some power that courts technically have. Like this is why it's insane. If the Trump administration is like, no.
And when distinguishing between
Like this is why it's insane. If the Trump administration is like, no.
And when distinguishing between the types of contempt, there are two broad categories: criminal versus civil, and direct versus indirect. Now, civil contempt is remedial rather than punitive, and serves only the purpose of the party litigant, and is intended to coerce compliance with an order of the court or to compensate for losses or damages caused by noncompliance. When civil contempt is at issue, the party moving for a contempt finding bears the burden of showing by clear and convincing evidence that contemptors violated a specific and definite order of the court. And there are two types of civil contempt. Coercive civil contempt aims to compel someone to comply with a court order rather than punishing them for disobedience. The court imposes sanctions like fines or jail time to pressure a party into obeying the order, and the contemptor in a coercive civil contempt action is said to possess the keys to their own cell, because they can immediately end the sanctions with simply complying. The classic example is a witness who refuses to testify despite a court order. That person may be jailed until they agree to testify. And the other kind of civil contempt is called compensatory civil contempt, where the purpose is to award compensation to the party harmed by the contemptuous behavior. For example, if a company violates a court order and causes financial harm to another party, the court may order the violator to reimburse the injured party for the losses. But like private parties, government agencies and officials may be subject to civil contempt. But if the initial burden is met, then the burden shifts to the contemptors to demonstrate Trump officials have been held in civil contempt of court before. In 2015, the Obama Department of Education fined Corinthian colleges. A court directed the Department of Education to stop collecting on the loans, but when the Trump administration took over, the Department of Education continued to build the 16,000 students who Corinthian defrauded. Education Secretary Betsy DeVos defied a court order to stop collecting student loan payments. And a federal judge ruled that, quote, "There is no question that defendants violated the preliminary injunction. There's also no question that the defendants' violations harmed individual borrowers who were forced to repay loans either through voluntary actions or involuntary methods, offset from tax refunds and wage garnishments, and who suffered from the adverse credit reporting. Defendants have not provided evidence that they were unable to comply with the preliminary injunction, and the evidence shows only minimal efforts to comply with the preliminary injunction." The court found DeVos in civil contempt and fined the agency $100,000, which was paid to the impacted students. Now that takes us to criminal contempt. The primary aim of criminal contempt is vindicating the authority of the court. To prove criminal contempt,
jail his ass. Put his ass in jail.
the court must show that a clear and specific court order was in place and the contemptor knowingly and willfully violated the order. Since criminal contempt is punitive in nature, the standard is beyond a reasonable doubt. And the court's authority to impose criminal contempt sanctions come from Rule 42 of the Federal Rules of Criminal Procedure. Rule 42 states, "Any person who commits criminal contempt may be punished for that contempt after prosecution on notice." And criminal contempt of court is generally recognized as direct or indirect, depending on where and how the contemptuous behavior occurs. Under Rule 42A, contempt is indirect when it occurs out of the presence of the court, requiring the court to rely on the testimony of third parties for proof of the offense. If this is the case, the court must hold a separate hearing to determine whether the contempt occurred. For example, if someone failed to pay court-ordered child support, this would be indirect because the failure happened outside of the courtroom. And the same is true if someone failed to turn over subpoenaed documents or disobeyed a restraining order, but contempt is direct when it occurs under the court's own eye and within its own hearing. The judge can immediately see or hear the contemptuous behavior and can punish it immediately. Direct contempt includes exactly the type of conduct you would expect: a witness openly refusing to answer a judge's questions, or a party disrupting court proceedings with outbursts.
One more word out of you, Mr. Reed, and I'll hold you in contempt. I hold myself in contempt!
And here, regarding the case of the putative Venezuelan migrants who were renditioned to El Salvador, if Judge Boasberg is considering criminal contempt to punish the government, then he would have to weigh whether the government's actions were direct or indirect. The failure of the government to turn the planes around happened outside of his courtroom, so it would qualify as indirect contempt. However, I suppose that there's an argument that the DOJ lawyers were in contempt of court because some of the contemptuous conduct occurred inside of the courtroom. The parties took a break to determine whether the airplanes had already taken off, and the judge orally told them to turn the planes around, and the lawyers indicated that they would comply with the order. But direct contempt provides for summary disposition. No federal court is going to punish the government without a full hearing, especially since the government will appeal any contempt order. And it's better for all parties to have a complete factual record justifying whatever the court decides to do, whether it's civil or criminal. The problem is that the government is trying to prevent Judge Boasberg from undertaking the fact-finding necessary to develop a complete record about the flights to El Salvador. The judge has repeatedly asked the government to answer questions, but the government has refused to provide any answer. And then, sensing that Judge Boasberg was moving closer to a contempt finding, the administration suddenly claimed it was considering invoking the state secrets privilege. This prompted a new round of back and forth between Judge Boasberg and the government, which finally ended with the government asserting it had a national security reason to refuse to answer any questions about the flights. But it certainly seems like the administration's privilege argument seems to be made in bad faith. They didn't raise it until the judge continued to investigate, and a lot of the information about the flights is already in the public record, including a bunch of propaganda videos that they made at the time, and the first reference to privilege came from a declaration by an ICE official in a
I think none of this matters of the Supreme Court ruling saying his order was wrong. It still matters because the Supreme Court, just like the lower courts, have, I mean, it's still a part of the judiciary. So it technically still matters right now, depending on whether or not Trump will decide to do the thing, to do the damn thing that is, that will eventually turn the U.S. Constitution into a piece of toilet paper. You know what I mean? Like, it just, this is, I guess they could just keep stalling. That's usually how you can effectively refuse to comply with a direct order from the Supreme Court. Just kind of ignore it. I mean, this is one of the many cases that the Trump administration's actions have created that is boundary breaking, precedent setting, truly the next stage of American fascism. This is what I've been talking about. On the immigration front, this is one of the many court cases. On the First Amendment side, also tied back to immigration, it's yet another incredibly important court decision. Like, this is the moment where either the institution starts serving the fascist agenda and the rules, the legality doesn't matter anymore. It's more so an argument about morality. Like, this is the moment where, is slavery legal or not? Okay, that's basically it. You know how we talk about how laws don't mean anything if those laws are directly and openly unjustifiable? And we point to the racial purity laws in Nazi Germany or slavery laws in the United States of America. This means, are we crossing the legal Rubicon or not? Are we just completely dismantling any persuasive power that the judiciary has, therefore completely dismantling the judiciary, or I guess turning it into a puppet of the federal government, which in some instances it has acted like that regardless. But I mean, this is a very important moment, I think, in American history, depending on what the Trump administration does.
Regional office in Texas who would not have been privy to any cabinet level discussions. Now, Secretary Rubio, AG Pam Bondi, and DHS Secretary Kristi Noem say that the information about the flights must be kept secret for sensitive national security reasons. And they claim they can't even show it to the judge in camera, meaning privately in chambers, because Trump's policy goals must never see the light of day. Of course, irony of ironies, they made these arguments just days before Secretary of Defense Pete Hegseth and other high-level cabinet members leaked active war plans by including the editor-in-chief of The Atlantic in their Signal group chat. And then they claimed none of that information was classified or sensitive national defense information. Now, notwithstanding the onslaught of scandals coming out of the Trump administration, state and federal officials rarely screw up so badly that a judge finds them in criminal contempt. But when a public official flouts the courts and inflicts serious damage on other people, the courts often have no choice. For example, former Maricopa County Sheriff Joe Arpaio established a policy and practice of racial profiling Latino drivers.
By the way, this video is outdated at this point because, I mean, there's still a lot in it that's important, especially at the beginning where he talked about like the historic precedent for finding yourself in violation of Supreme Court orders. But the reason why it's, I guess, technically outdated is because as of this moment, as of a couple hours ago, the Supreme Court did decide unanimously to return the Maryland man that was falsely sent to El Salvador, despite having a previous court ruling that protected him because he had a withdrawal order.
And asking them to prove they were legally entitled to be in the country. A federal judge ruled the
Am I missing something? Are all this irrelevant per Trump versus U.S. presidential immunity? No, this doesn't render that moot.
Policy was illegal, but Arpaio directed his deputies to ignore the court and continue to racially profile drivers for 18 months. The sheriff's office illegally detained.
That's not what the SCOTUS said, though. They said that the admin should facilitate the process of bringing him back, but did not require that they do so. Huh. There is a video from earlier today.
So remember when we said the Trump administration,
which I have on the docket as well. The video that I had on the docket already, which was this, what do you call it? Which is this one, which is SCOTUS, due process in theory, deportation.
Snatched an unknown number of immigrants from the streets of America without any due process, no hearings, no trials, and renditioned them off to detention centers in Trump-friendly jurisdictions, then sent them on flights to a Salvadoran torture prison where they will be placed under the watchful eye of the guy who describes himself as the coolest dictator in the world. Well,
I mean, I guess the verbiage is like must facilitate. But I mean, that's pretty clear, no? Must facilitate the return. Like, what are they supposed to do? Must return? They said must. SCOTUS also referring it back to district court to further clarify what facilitate return means. This is far from over. Facilitating without a deadline means nothing. They could just delay for years. No, I know. It could be ass covering. It could be ass covering from the Supreme Court. So that they say, well, we gave the lawful order, but then we left it in an open-ended manner. So they could just turn around and say, oh, we're trying to facilitate. We're following the lawful order of facilitation. That doesn't mean we're actually returning him. They can hold off on doing it. Yeah, new Supreme Court order requiring U.S. to facilitate return of Kilmar Abrego Garcia from El Salvador could open the door to similar legal claims by those Trump deported last month under the Alien Enemies Act. The language is vague, but logic would suggest they mean bring him back. Yes. But there's two different points here that are a matter of that could be up for contention. One, the fact that CCOT is in a sovereign nation, totally independent from the United States of America, which clearly is a legal argument that they're going to entertain. Okay. And the second part of the problem is, they'll claim that they are facilitating the return, but facilitating the return can mean tomorrow. It can mean 3 years from now. It can mean never. It was part of the reason why I said that the Biden administration, for example, had the power to de facto delay student loans. That's directly within the power of the executive. They can't outright, let's say the Supreme Court says you can't outright abolish student loan debt, but you could technically delay student loan debt permanently. It's a power that they have. It's a power that they've used. It's a power that they used during COVID. It was a matter of the Biden administration refusing to use that power that they had that stopped them from doing so. So I don't know. Decision is unanimous, by the way, and it suggests someone held overseas can still be given due process. Yeah, will require the Trump administration to facilitate the return of Kilmar Abrego Garcia. How much infighting in the Supreme Court prevents outright corruption? What? He cooked. CNN analysts are saying that El Salvador cooked. Just say no still, and the U.S. is still facilitating. Yeah, I saw the Mahmoud Khalil memo as well. It's right here, which is insane. This is also complementary to the thing that we're discussing. As you guys know, Mahmoud Khalil was also kidnapped and black-bagged from Columbia University, where he resided, as a green card holder for seemingly no crime whatsoever, but simply an awesome power that previously, at least as far as I understand, not really been utilized by the Secretary of the State. The justification for why he was black-bagged was that he was determined to be a threat to American national security. The real reason as to why they were doing that, or at least the evidence they suggested as to why he was a threat to national security, was, well, as follows. This is what they said. Information provided by the DHS, ICE, HSI regarding the participation and roles of Bleep and Mahmoud Khalil in an anti-Semitic protest and disruptive activities which fosters a hostile environment for Jewish students in the United States. My determination is also based on citations for unlawful activity during this protest. The public actions and continued presence of I don't know why this is censored, but and Khalil in the United States undermine U.S. policy to combat anti-Semitism around the world and in the United States. In addition to the efforts to protect Jewish students from harassment and violence of the United States, consistent with Executive Order 14150, America First Policy Directive, to the Secretary of State, the foreign policy of the United States champions core American interests and the American citizens condoning anti-Semitic conduct and disruptive protests in the United States would severely undermine the significant foreign policy objective. No hard evidence whatsoever, but vague generalizations. Incredibly, incredibly dangerous. I don't think that the judge that required hard evidence will see this as like reason alone to justify the deportation. After the immigration judge in Mahmoud Khalil's case ordered the government to provide evidence to justify deporting him, this is what they filed. This is from Janine Yunus, Palestinian American civil liberties free speech attorney. I've been a lawyer for 14 years, she says, and a criminal defense lawyer for 9 of those years, and I've never seen anything like this. Totally nebulous, vague allegations about involvement in anti-Semitic protests and disruptive activities without any specific attributions of unlawful activity or even anti-Semitic speech to Khalil himself, which in any event is protected. The U.S. rightly does not have hate speech laws. That's the other side of this. Even if they were to ascribe anti-Semitic speech directly to Mahmoud Khalil, this would not actually be reason alone to fucking deport him or to revoke his green card. Do you understand? You can't do that. That's why I keep repeating, and I stress this, the importance of this. The First Amendment protects you from exactly this, government action. This is why you can't just like deport Nazis just because they are Nazis. Although you might want to do that, you literally cannot do that. This is precisely the reason why the First Amendment is the reason why you can't do that. So this would destroy the First Amendment. It would destroy it in its entirety. There would be no more First Amendment. This would be the boundary-breaking, precedent-setting case that would erode the constitutional protection that every citizen and non-citizen alike has in the United States of America. In the U.S. and all civilized societies, if the government is going to punish someone under the law, it had better provide evidence for specific forms of unlawful activity by the individual they're targeting. Not only has the government entirely failed to do that here, but it's obvious its case is predicated on punishing First Amendment protected speech and protest. Like even with Charles Manson, for example, you have to provide direct evidence that Charles Manson was influencing people to take action, right? Even in RICO cases, you have to basically tie back with hard evidence how the influence of the person who is in charge of the criminal organization and their opinions and their actions are basically are basically why these sorts of crimes are occurring. Okay? You can't just simply go, yeah, this guy is a bad guy. I've decided he's a bad guy. I decided he did a bad thing, so we're deporting him. You can't do that until now. Yeah, this speculation, I think, is not incorrect. My theory on what happened, Beitar, Canary Mission Fed senators fabricated lies past the DHS and ICE. Deportation orders were issued without vetting. They thought Khalil was on a visa, not green card. Now they look incompetent and have to reconsider their sources. Janine speculates further, says, agreed. I agree with the speculation, by the way, because they literally initially stated that Mahmoud Khalil was on a student visa. That is too large of an error to make. It is shocking. And then they just continued along with it. Now they box themselves in and won't admit they made a mistake and maybe should have done a little work before accepting at face value the words of an explicitly genocidal terrorist group. Yeah. Anyway. Can you please boost this message for Chad to see the Encampments movie this weekend? Maybe the last one in most places, unless more people go. His center's Mahmoud Khalil and his work is very good. Yeah. What is this? A disgraced former cop turned private prison contractor approved the report claiming Andrew, the gay makeup artist, was a gang member based on mom and dad tattoos. This cop has been caught lying and was fired after drunk driving into someone's house, but he has now apparently been given the power to single-handedly sentence innocent people to life in a torture dungeon. Yeah. Is Beitar run by the guy trying to have sex with Brace Belden in the park? Yes. Beitar is run by that guy.
We have an update. Things have gotten worse. Things have gotten much, much worse. And honestly, despite everything that's happening in the world, I think this ought to be the most important news story in the country. Now, these actions triggered a wave of lawsuits that we previously covered. Then at the 11th hour, Judge Boasberg swooped in to save the day, ordering the government to turn the planes around. Then the government thumbed its nose at the order and continued to send people to the gulag with zero opportunity for due process, while simultaneously declaring that their inability to do so was an emergency worthy of a stay by the DC Circuit Court and eventually the Supreme Court. Now, this broke with 249 years of American legal precedent, and this could very well be the beginning of the end of one of our country's founding legal principles, the right to due process. None of the individuals detained have ever been found guilty of any crime, nor were any of them charged with one. In fact, most of them were on the government's radar because they were attempting to go through the U.S. immigration system the legal way, via immigration courts. And yet Donald Trump has appointed himself their judge, jury, and executioner.
They emptied jails out. Other nations emptied their jails into the United States. That's an invasion. And these are criminals, many, many criminals. Murderers, drug dealers at the highest level, drug lords, people from mental institutions. That's an invasion.
Whether citizen or not, anyone detained by the U.S. is entitled to due process as a constitutional right. But those rights are in question now. So first, a quick refresher of the facts, horrifying as they are. The named plaintiffs, identified only by their initials, are a group of 5 Venezuelan nationals who are being detained by the government. The lead plaintiff, JGG, arrived in the United States in March of 2024 and sought asylum. According to his court filings, he fled Venezuela because he had been tortured, arbitrarily imprisoned, and beaten by the Venezuelan police, whom he claimed will continue to retaliate against him because his stepfather is a political dissident. Like many of the other plaintiffs in this case, JGG was already going through the legal steps of the immigration process. He even had a hearing scheduled regarding his asylum application. And I will remind you, asylum is legal immigration. And while it may or may not be true that everything he has alleged is true, that's the purpose of the asylum process, to determine if it's true. And if it is, at the end of that process, he would be granted asylum and would be a legal resident in the United States. Apparently, though, that process was moving too slowly for the Trump administration because instead of waiting for the immigration system to properly adjudicate JGG's asylum case by doing, inefficient things like evaluating evidence, allowing him to have a hearing, and requiring adjudication by a neutral third party, the administration detained him and then presented JGG, a native Spanish speaker, with papers in English while falsely claiming that he was going to be released. Once he signed those papers under that false pretense, the government whisked him away to a detention center in Texas. At 3 o'clock in the morning on March 14th, 2025, he was awakened by the guards and told that he was going to be transferred somewhere else. The guards refused to specify where he was going to be sent or why. That transfer was apparently thwarted by a mechanical problem with the plane, which allowed JGG to contact his attorney and file this lawsuit on the morning of March 15th. And I will also remind you that the plaintiffs were not seeking full residency in the United States. They were simply asking for regular due process and to let the process of the immigration courts play out. But in their lawsuit, plaintiffs stated that they had heard that the Trump administration planned to invoke the Alien Enemies Act to remove Venezuelans to El Salvador's notorious prison, the Terrorism Confinement Center. And as we've discussed before, the Alien Enemies Act is a 1798 law that was designed to give the president sweeping power to expel immigrants in times of war, and it has rarely been invoked since. And to be clear, when I say that El Salvador's Terrorism Confinement Center is a torture prison, I'm not exaggerating. The BBC published a shocking expose on the prison in 2023, highlighting its various human rights abuses, which included overcrowding, no windows, fans, or air conditioners to combat the year-round tropical heat, no outside recreation, and no familial visitation. Salvadoran officials have proclaimed that they don't expect the prisoners will ever be released. According to court filings, police beat newcomers to the prison with batons, prisoners are sent to dark basement cells where they're beaten daily, and one prisoner even required an operation for a ruptured pancreas and spleen. Scholars have stated that 375 detainees have died in Bukele's Salvadoran gulags, but some estimate that...
Bro, this stuff is so heinous. They got Legal Eagle to start making videos that are more overtly political than ever before. I feel like in the past, he always towed this line. He's always been a liberal for sure, and you can tell, but rarely does he ever make like, I feel like he doesn't, he normally wouldn't go this hard on anything. He's a liberal for sure, but in his commentary, you can kind of get a you can kind of get a sense that like he defends the infallibility of institutions in general. He's not, he's not going to go above and beyond in terms of his commentary. I feel as though him, Philip DeFranco, many of these other guys, CoffeeZilla, regardless of their own personal biases, I feel like their commentary on issues such as this one have often been more restrained. And slowly but surely, you see his commentary evolve through the process where it's just like they're sending people to a concentration camp.
The number is more than 1,000. So upon hearing that the president was about to invoke the Alien Enemies Act to send them to a torture prison, the plaintiffs understandably were terrified and implored the DC District Court to issue a TRO preventing them from being extraordinarily renditioned to El Salvador based on the groundless whims of the Trump administration. And later that same day, the Trump administration confirmed the rumors by issuing a proclamation declaring that it was invoking the Alien Enemies Act to apprehend, detain, and remove members of the Tren de Aragua gang, a violent Venezuelan gang that has been designated as a terrorist organization. Is staging an invasion or predatory incursion on behalf of or in collaboration with Venezuela's dictator Nicolas Maduro. Now, if you think that that seems a bit of a stretch, I'm with you, and we'll get to that in a bit. But the government has claimed that JGG and the rest of the plaintiffs are being renditioned because they are members of Tren de Aragua. The plaintiffs have all argued that this is not true. Several plaintiffs have pointed out that the government's suspicions are based on the specious fact that they have tattoos, including a tattoo of an eye and a tattoo of a rose and a skull.
And a tattoo of mom and dad, a tattoo of autism awareness. It is such an insanely high bar of punishment for such a low bar to clear. It's just like, I've never seen something so erroneous. It might as well be just like, I've decided your vibes are off, so sorry, you're going to fucking perma jail.
The government has provided no evidence to support this assertion that any of the members are in fact members of Tren de Aragua. Now, in ordinary times, there are actual processes for adjudicating these kinds of questions of fact, and they're called courts. This is why courts exist. If the administration wanted to credibly accuse the plaintiffs of membership in Tren de Aragua, they could have pursued criminal charges or allowed plaintiffs to continue to work their way through the immigration system. But instead of gathering evidence and laying out a case against the plaintiffs, the Trump administration just stamped them with the terrorist gang members designation and sent them for an indefinite stay in a Salvadoran gulag. DC District Court Judge Boasberg came in on March 15th by issuing a TRO from removing any of the individuals.
Like, this is why he's a lib, you know what I mean? Because like Boasberg is not exactly a woke libtard himself, you know what I mean? He's a conservative judge that would have probably processed all of these deportations in the most expeditious manner, but the only reason why I didn't is because there was clearly no fucking due process.
Individual plaintiffs from the United States for 14 days. Judge Boasberg also provisionally certified a larger class of plaintiffs, specifying that all non-citizens in U.S. custody who are subject to Trump's proclamation also could not be removed for 14 days. And in the March 15th hearing, Judge Boasberg told the Trump administration's attorney that, quote, "You shall inform your clients of the order immediately, and that any plane containing members of the class that is going to take off or is in the air needs to be returned to the United States." As Judge Boasberg later pointed out, his orders were quite narrow. He said, quote, "Neither order required the government to release a single individual from its custody. Neither order prevented the government from apprehending anyone pursuant to the just published proclamation, and neither order prevented the government from deporting anyone, including plaintiffs, through authorities other than the proclamation, such as the Immigration and Nationality Act." And indeed, as the plaintiff last month designated Tren de Aragua a foreign terrorist organization, members of that gang are already inadmissible to, and thus deportable from, the United States under the Immigration and Nationality Act. Now, the Trump administration, desperate to avoid having to actually present evidence before indefinitely detaining people in a torture prison, filed an appeal to the DC Circuit that same day. In the meantime, while the Circuit Court appeal was pending, the Trump administration decided to continue renditioning people out of the U.S. in contravention of Judge Boasberg's March 15th TRO. According to the government's own statements, 2 planes left prior to Judge Boasberg's ruling and would have been in the air and thus still subject to his order at the time that the order was issued. Indeed, the administration bragged about its continued non-compliance, declaring on March 31st, after Judge Boasberg had extended the TRO until April 12th, that, quote, last night in a successful counterterrorism operation with our allies in El Salvador, the United States military transferred a group of 17 violent criminals from the Tren de Aragua and MS-13 organizations, including murderers and rapists. So on March 16th, Judge Boasberg set another hearing to discuss the Trump administration's non-compliance, and the administration filed a motion to vacate the hearing, arguing that the court lacks jurisdiction to, quote, interfere with the president's National Security and Foreign Affairs Authority, led by Pam Bondi. Trump's Department of Justice had the temerity to argue that because Judge Boasberg's more specific order to turn those planes around was issued orally, it wasn't actually an order. It was really more of a suggestion. Yes, that's what they actually argued in court. Judge Boasberg was apparently unimpressed with the administration's legal wrangling because he held the hearing anyway and ordered the government to submit sworn declarations certifying that no one on any flight departing after the TRO was issued had been removed solely on the basis of the Alien Enemies Act. He also ordered the Trump administration to specify when the proclamation was signed, made public, and went into effect, and how many individuals subject to the proclamation are still in the U.S. and in U.S. custody. The administration responded that it didn't think that it needed to answer the judge's questions about the flights, but that if it must answer those questions, it will only do so in camera or with an ex parte declaration, meaning that they would only do it in the judge's chambers outside of the eyes of anyone else. Now that was strange because the administration had broadly publicized many details of these renditions. Bukele himself had posted on Twitter on March 16th stating, quote, today the first 238 members of the Venezuelan criminal organization Tren de Aragua arrived in our country. They were immediately transferred to CICOT, the Terrorism Confinement Center, for a period of 1 year, renewable. The United States will pay a very low fee for them, but a high one for us. Bukele also bragged about how the prisoners in CICOT are being used as slave labor, stating, quote, over time, these actions, combined with the production already being generated by more than 40,000 inmates engaged in various workshops and labor under the Zero Idleness program, will make our prison system self-sustainable. In response to these declarations, Secretary of State Marco Rubio replied on Twitter, quote, thank you for your assistance and friendship, President Bukele. So it was clear that the administration wasn't exactly keeping this a secret, and it was odd that they would argue to the court that this was super sensitive information. Judge Boasberg, though, generously allowed the administration to file its answers ex parte and under seal. But this was still not good enough for the Trump administration, which decided that it didn't want to answer the judge's questions at all, and instead filed a motion to stay the judge's order to disclose details about the flights, claiming that, quote, the court's continued intrusions into the prerogatives of the executive branch, especially on a non-legal and factually irrelevant matter, should end. Defendants whinged about the court's, quote, micromanaged and unnecessary judicial fishing expeditions, and claimed that, quote, there is no serious dispute that the government complied with the minute order. But the Trump administration argued that it needed the stay because it was evaluating whether to invoke the state secret privilege to portions of the information the court was seeking, and that a stay was warranted while the appeal to the DC Circuit was pending. Defendants also threw in a few arguments about how the invocation of the Alien Enemies Act wasn't reviewable by the court, and, just to add insult to injury, stated outright that they did not trust Judge Boasberg to not share the ex parte information with the plaintiff, stating, quote, the government does not currently have any assurance at this time that information provided to the court on an ex parte basis would not subsequently be provided to the plaintiffs or the general public before the government could seek appellate review of that further disclosure. But Judge Boasberg was not having it. He granted the government an additional day to provide the information, but sternly called defendants out in their non-compliance, stating, quote, to begin, the court seeks this information.
Most of them are actual criminal scum, though. You mean the administration? Yeah. People in the White House? I agree.
Not as micromanaged and unnecessary judicial fishing expedition.
This right here betrays reality, and it shows that you still, in spite of your fascist rhetoric, have a conscience inside of you eating away at your brain, your heart, your soul. What do I mean by this? Because you have to fantasize about these people that are unjustly sent to the slave labor camp being violent criminal scum. It's clear that there's no evidence for that, okay? It's very clear that there's no evidence for that. That's precisely the reason why they're violating due process. It's the whole reason why this is fucking happening to begin with. This back and forth in the judicial system is occurring. But you ultimately think it is impossible. Like, these people have to be violent criminals. I'm going to fantasize that they are violent criminals in your mind. I'm not talking about the guy who got deported. Who are you talking about? This conversation is entirely about people that have been deported in an unjustifiable manner due to erroneous claims made by the Department of Homeland Security without any due process whatsoever. In your mind, you're fantasizing about an invisible criminal doing invisible crimes that you haven't actually had the state prove, not recognizing that the erosion of due process will inevitably harm you as well, because when the state decides that there's no need for due process, that means you can be branded a criminal without any evidence whatsoever, and then shipped off to a fucking El Salvador slave colony, and then never to be returned, by the way, from said slave colony. These are all the fucking different ways in which the government is operating. But in your mind, you're like, oh, well, I hope that they're all criminal scum, because otherwise, what is the reason for all of this brutality? Because you cannot, in good conscience, recognize that the American government is the one that is doing the wrong here. About all the rest of them, the ones that aren't even shipped from the US, what are you talking about, dude? What the fuck are you talking about? There's been numerous investigative reports that have been conducted on who has been deported. 75% of those deported to CCOT had no criminal record nor any allegations against them. 75%. And in the 25% that they have, not all of them are fucking gang members to begin with. Their crimes are things as silly as like trespassing. The American president is a convicted felon. He is literally more of a real criminal than the fucking people that are being deported. You understand?
But to determine if the government deliberately flouted its orders issued on March 15th, 2025.
Yeah. One dude driving a bike in the wrong lane. Yeah, it's just like parking tickets. Parking tickets, dude. It's fucking nuts.
And if so, what the consequences should be. And Judge Boasberg.
And if your argument is, oh no, I was just talking about all the people that are MS-13 and CCOT prior, okay, you do understand. Even the people, yeah, exactly. Even the people in that prison already are not all fucking criminals, dumb fuck, chatter. CCOT is a horrendous fucking terror camp. Do you even know the process in which these people get shipped into this facility internally inside of El Salvador? Do you know the process? Do you know how it works? Government stooges come to your house overnight, black bag you, put you in a room where a fucking judge is wearing a balaclava, 300 people at a time. That judge wearing the balaclava decides all 300 are actually MS-13. It's over. That's it. That's what it takes to get to CCOT. That's what it gets. That's what it takes for you to be disappeared inside of El Salvador. So no, even the people that are in that prison are not all violent scumbags and criminals.
Expressed surprise at the government's claims of secrecy and referenced Secretary Rubio's post on Twitter, proudly sharing details about the plane's arrival in El Salvador. The judge also blasted the administration for appearing to flout his order, stating, quote, as the Supreme Court has made crystal clear, the proper recourse for a party subject to an injunction it believes is legally flawed, and is indeed later shown to be so flawed, is appellate review, not disobedience. So while the fight over disclosing the flight details was ongoing, the administration also moved to vacate the temporary restraining order, arguing that Judge Boasberg had no jurisdiction over the case and that the plaintiffs had not satisfied the TRO requirements. Judge Boasberg declined to vacate the TRO and rejected the Trump administration's arguments that he could not consider the case, finding that, quote, the court need not resolve the thorny question of whether the judiciary has the authority to assess this claim in the first place. That is because plaintiffs are likely to succeed on another equally fundamental theory. Before they may be deported, they are entitled to individualized hearings to determine whether the act applies.
I'm done. I can't talk about this anymore. I'm fucking I'm tired. I'll cover it tomorrow in terms of like the Supreme Court decision